Good morning, I'm Gretchen Hall. It is a Friday, the 8th day of August, bringing you Morning Matters. Because your mornings matter, let's get to the stories that matter today. Ending speculation about her whereabouts, Vice President Sara Duterte has made an appearance in Davao City. There, she called for respect regarding the Senate's decision to archive her impeachment case and stated that although she intends to clear her name, now is not the time. Some members of the Senate minority explained their opposition to archiving the impeachment complaint against Vice President Sara Duterte. Senator Kiko Pangilinan, for one, points out that the Senate did not convene as an impeachment court before making its decision. And President Bongbong Marcos insists that online gambling should not be compared to pogos amid ongoing discussions about a potential ban. The president assured that he will convene a meeting with key stakeholders to establish a clear policy for online gambling. Welcome to our program, Morning Matters, where we talk about the issues you need to know for the rest of your day. Now, first on the agenda. After questions were raised about her whereabouts amid heated political issues, Vice President Sara Duterte appears in Davao City. And there, she finally breaks her silence on the Senate's move to archive her impeachment case. Here is the report.
Vice President Sara Duterte attended the Thanksgiving Mass at San Pedro Church in Davao City on Thursday. This is part of the Kadayawan Festival celebration this month. There, the Vice President said the Senate's decision to archive her impeachment case should be respected.
I wanted a bloodbath, meaning I wanted all the pieces of evidence from the prosecution and all the pieces of evidence from the defense presented for everyone. But unfortunately, wala na siya. So possibly, wala ta kibalo, 2026, 2027, 2028, na ay mga mag-file na po og impeachment. That will be another opportunity to answer.
On Senator Alan Peter Cayetano's statement that if people really wanted VP Sara removed, they should just defeat her in the 2028 elections. This was the Vice President's response.
Well, yes, ang katuang mga senators na sila kaugalingon po nila na mga stand and opinion, and we should respect each manifestation and stand sa ato ang mga senators.
According to the Vice President, her father, former President Duterte, was pleased with the Supreme Court decision declaring her impeachment case unconstitutional.
Tinawagan siya ng kanyang lawyer at ibinalita sa kanya na nanalo siya sa Supreme Court case, na mag-relax daw siya for one day. Hindi daw siya mag-meetings at hindi siya mag-physical therapy dahil gusto niya daw i-enjoy yung moment na nanalo yung kaso sa Supreme Court.
Vice President Sara Duterte also held a Thanksgiving celebration together with her legal team and petitioners advocating for the dismissal of her impeachment case. Davao City councilors also attended the gathering. The Vice President's final engagement on Thursday was a meeting with barangay captains inside Davao City Hall. She was scheduled to fly back to Manila last night.
Vice President Sara Duterte also addressed developments related to the ICC case of her father. VP Sara confirmed that Hanilet Avancenia, the former president's common law wife, was recently barred from visiting him at the ICC detention facility in The Hague. But according to the vice president, no explanation was given for the ban. Recall that Avancenia said the restriction was because she allegedly discussed the case with Duterte over a phone call, which she denied.
Hindi ko alam kung ano ang rason dahil hindi pinakita sa amin yung papel kung ano yung rason ng pagbabawal ng pagbisita ni Ms. Hanilet Avancenia.
Some members of the Senate minority explained why they voted no to archiving the impeachment complaint against Vice President Sara Duterte, citing pending motions for consideration before the Supreme Court. Meanwhile, Senator Ping Lacson, the only one who abstained, said he will wait for the High Court's ruling. Here is the report.
Senator Kiko Pangilinan is raising concerns over the Senate's decision to archive the impeachment complaint against Vice President Sara Duterte, suggesting the move may have fallen short of its constitutional duty. In an interview with a big story, Pangilinan said the chamber should have waited for the Supreme Court to rule on the pending motion for consideration.
Talagang gigil na gigil tapusin. Nakakalungkot. We actually abdicated our constitutional mandate and duty to uphold and defend into the Constitution as having the exclusive jurisdiction over the case.
Pangilinan also pointed out that the Senate did not convene as an impeachment court before making its decision, something he believes should have been done to ensure due process.
How can the Senate archive a complaint that was not referred to it? It was referred to this Senate impeachment court. Walang jurisdiction yung Senado in plenary sa impeachment complaint.
Senator Risa Hontiveros also questioned the urgency behind the move. Hontiveros told Storyco that the Senate should have acted as early as February when it was first transmitted by the House of Representatives. Hontiveros also stressed that the complaint is not necessarily over and could still be revived.
Definitely hindi pa patay yung impeachment complaint na iyan, naka-archive, ibig sabihin parang sa library kung naalala pa ng ating manonood, kumbaga naka-file away dun sa archives. Pero extra effort para lang hukayin yan at ilabas sa archive.
In 1PH's One Balita Pilipinas, Senator Ping Lacson, who abstained from the vote, said he's withholding judgment until the High Court issues a final ruling, out of respect for the judicial process.
Sa archive, nag-abstain ako kasi nga, lagi ko sinasabi na dapat igalang at sundin ang Korte Suprema. Teka muna, paano kung dumating ang panahon na halimbawa yung Supreme Court dahil sa MR, ni-reverse na lang sarili at sinabing pwede yung Senado na mag-proceed na mag-trial.
Senate Minority Leader Tito Soto, meanwhile, emphasized the importance of protecting the Constitution, regardless of political positions.
Talagang gusto lang nila na ma-dismiss eh. As a matter of fact, pagka yan nagkaroon ng motion to bring back from the archive, dahil let's say sabihin ng Supreme Court, nag-reverse. Tignan mo kung ilan na mag-o-object dyan. Ayaw lang nila. Ako naman, whether ayaw mo o gusto mo, preserve the Constitution.
When we return, we will be joined by Liberal Party President Erin Tanyada to weigh in on the Senate's decision to archive the impeachment complaint against Vice President Sara Duterte. Don't go away. More on Morning Matters when we return. Good morning, I'm Gretchen On here on Morning Matters. We talk about the most pressing issues and give you the context behind the headlines. ML Representative Laila de Lima is questioning the Senate's swift move to archive the impeachment case of Vice President Sara Duterte. De Lima called the decision disconcerting and premature, noting that several motions for reconsideration remain pending before the Supreme Court. She added that the case could have been tabled instead, as suggested by Senator Tito Soto, until the High Court rules on the matter.
Bakit sila nagmamadali? Ano bang diferensya? Hindi po ibig sabihin dahil immediately executory, final na. Kasi nga, meron pang motion for reconsideration. Pina-comment pa nga ng Korte Suprema yung petitioners, sila Vice President Sara Duterte and si Attorney Torion. Kung talagang final na yan, hindi na sana pinansin yung mga MR, including yung mga motions for reconsideration and intervention filed by the group led by Representative Percy Sendanya and yung sa Tindig Pilipinas.
Liberal Party President Erin Tanyada also slammed the Senate's archiving of the impeachment case. He accused the chamber of delaying the case for months, only to act swiftly after the Supreme Court ruled, which is still facing a motion for consideration. He added that the Senate suddenly knew the meaning of forthwith when it served Duterte's interests. Let's discuss that further with Liberal Party President Erin Tanyado, who is joining us this morning on inside our studio. Hello.
Hello,
Welcome
good
to our
morning,
show.
Gretchen, and to all your viewers.
Welcome back. Ano po bang difference ng forthwith at immediately? Kasi pati yung pinagtatalunan, ano?
Tingin ko't pinagtatalunan ng mga taga-UP.
Kung anong difference? Kasi si SP Cheese, yun ang binabanggit niya, no?
Yes, but I think it's very clear to everyone what forthwith means. Agad-agad, immediately. Although sabi ni SP Cheese na kailangan nakalagay yung word immediately. Mukha naman hindi, no?
Ano ba mas urgent? Sa dalawa?
Pareho lang yan.
Pareho lang.
Pareho lang. Kaya nga sinabi ko, bakit nung sinampa when the more than one-third, 215 congressmen, when they filed the verified complaint, no? Sinabi ni Cheese, hindi lahat nagtatanong noong February 5, forthwith, dapat agad-agad. Ngayon, na merong desisyon ng Korte Suprema at may motion for reconsideration, bakit hindi pwede maghintay ng konti para magkaroon ng decision? Ngayon mukhang nakilala nila ang anong ibig sabihin ng forthwith. Agad-agad i-dismiss yung complaint.
What was going on in your mind while you were watching the Senate hearing, the 6 hours of debate? Because you were with several of the senators in that room in other impeachment cases in the past, and just hearing the arguments being thrown back and forth.
I was not in the plenary, but I was monitoring it. I was listening to the arguments being given by the different senators, and the points that were raised by Senator Soto were very logical. No, number one, it is not the role of the Senate as a legislative chamber to rule on the impeachment, whether to dismiss or to archive or even to table. No?
It should convene as an impeachment court.
It should convene as an impeachment court. And I think that is the main point of the whole debate. Since they convened in June 11 to open the impeachment proceedings, logically, they should also close whatever they opened in June 11 if their intention was really to dismiss or archive the case.
But isn't that the reason why they amended the motion to dismiss to the motion to archive? Because the Senate exactly did not have jurisdiction over the matter.
But again,
right?
you go to the point. Does do the functions of the Senate, do they have the power to archive an issue that was open in the impeachment court? Should it not be the impeachment court that should order?
Because we're talking about the impeachment articles
Yes.
that have been archived,
Yes.
not the whole process.
Yes. So that I believe is a very logical and should be the step that should have followed if their intention was really to dismiss or to archive.
So if they did not have the power as the Senate, as a legislative body, what was the more rational or legal way forward? Should they have just waited for the Supreme Court's decision on the MR?
Yes, they could have
before
just
discussing it again?
Yes, two ways. They could have just laid on the table. No, let's not decide on this for this matter, this issue.
Which is the tabling?
The articles of impeachment. Let's not discuss it anymore because we are waiting for the decision of the Supreme Court. Again, they can also still argue that if that's the case, then let's open the impeachment proceedings, which Senator Risa was saying. We have 12 members of the Senate who have not yet taken their oath as impeachment trial judges, so might as well let them take their oath and then. These are technical issues, but I would believe that the most logical would have been the position taken by Senator Soto.
Well, at least he's there.
There.
Right. Okay, you called this a betrayal of public trust. Why so?
Well, the whole process now seems to be more difficult to hold accountable high officials of government. Under Article 11, public accountability of the accountability of public officials, there are ways. There are only five sets of people who can be impeached: President, Vice President, Supreme Court justices, Ombudsman, and constitutional commissioners. And they laid down, and then this is separate. This is also part of debate. It is not included in the functions of the legislative department, but it was separated. No, it was not in Article 6, but in Article 11. So the framers of the Constitution put premium on holding these individuals accountable.
A sui generis
Yes.
type of
Yes.
proceeding.
Yes.
Court, right?
And they laid down the procedure on how to hold these individuals accountable. One, any person can file a complaint in the House of Representatives, and as long as it is endorsed by one representative. Now, there was a initiate. No, if we look at Section 3, Articles 11, Section 3, Section 1, initiate was a word that had to be defined. And this was defined later in the case of Francisco versus House of Representatives. What do you mean by initiate in order to implement the one-year ban? So initiate should be filing and referral to the committee.
To the Justice Committee.
Yes. Now, that is one mode. And then the other mode is if, this is subsection 4, if one-third of members of the House file a verified complaint or resolution and voted upon, then it should be immediately sent to the Senate and trial shall forthwith proceed.
Pero ano po masasabi niyo sa sinabi ni Senator Marcoleta na hindi naman sila against dito, pero hilaw lang yung pagkakaluto nito. Kung if it was done right and according to due process, But the problem was there were three complaints, impeachment complaints, na inupuan ng Secretary General bago ni-refer to the Justice Committee.
So, these are now factual questions. No, again, just going back to history, because during the impeachment of former President Gloria Macapagal Arroyo, there were usually attempts to immediately, quote unquote, immunize her from further impeachment complaints. So people will be rushing right after the 1-year ban to file a bogus complaint just so that she would not be impeached. So what the Secretary General, from what I've understood in his statements, is that they were making sure, no, that there was nothing wrong with the first three complaints, and they held it. They held it based on the number of days allowed by the Constitution.
Which is also up for debate, right?
Up for
Contempt
debate.
o 11th day.
Yes, and it is a factual
Kasi 10 days lang pwede.
factual issue that could be resolved easily if the Supreme Court allowed an oral argument, allowed to present evidence, no? And it seems now that there are some misinterpretations by the court on the actual facts that happened.
Yes, you're correct, because even ABS-CBN
Yes.
corrected a statement in the decision of the SC,
Yes.
citing their article daw that they claimed in one of their articles that they said that wait lang, hanapin ko ha. That Vice President Sara, wait lang, that the House of Representatives did not
Vote.
go to a plenary vote
Yes.
upon transmission of the articles of impeachment to the Senate,
Yes.
which they verified and said that they did not state that. At wala silang article saying that. I mean, oo.
Precisely.
So was due process missing here in the Senate's Supreme Court's decision?
I wouldn't say, I don't know whether the word due process is would be used, but I think there's a misappreciation of the facts that actually happened. So in order to resolve that, maybe the Supreme Court now should ask for an oral argument in order to really find out what the facts are, in order to come out with a clear decision. But what is, again, disconcerting is they added requirements that do not appear in the Constitution, especially with regard to the 1/3 vote, which we call the fast track vote.
Which is, what did they add to the 1/3
That
vote?
that a copy of the articles of impeachment should be given to the
Should be served.
should be served to the
Accused.
no, and all the evidence also should be included, and that it does not appear in the
Well,
Constitution.
kahit nga sa ICC, hindi nila ginagawa yun ng isang sabay-sabay lang. Ano?
Yes.
Kasi parang may prosesong dadaanan.
So,
even the protection of the witnesses.
Kung sinasabi nila due process, ang due process nga, sinasabi rin ni former Justice Ascuna and all the justices, will happen in the trial in the Senate, in the impeachment court.
So the bar is a lot higher now.
The bar is a lot higher now.
And it's easier to just have a bogus complaint, in short, right? If the tendency is for this to happen, for bogus complaints to be filed to prevent the rightful impeachment of officials, then the Supreme Court should have acted in a way that actually protects
The
that
people.
mechanism,
Yes,
right?
yes.
Instead of the other way around.
And this is why we are saying that accountability now becomes harder. No, to impeach these individuals identified in the Constitution.
But I wanted to go back to the discussion of the previous impeachment cases kasi kayo po ay naging active, no? Lalong-lalo na dito nga po sa impeachment ni Chief Justice Corona. You were spokesperson of the prosecution.
Yes.
You were also part of the impeachment of Ombudsman Merceditas Gutierrez. You were one of those that defended the impeachment on the floor. What was the difference then? I mean, of what happened in terms of the filing of the impeachment complaint itself?
Well, with regard to, if we go to the very first, kasama ko si Senate President Cheese, si Senator Alan Cayetano, no, former President Noynoy Aquino, in the impeachment case of former President Gloria Macapagal Arroyo. So we went through the process. We didn't get the 1/3 requirement in order to fast track to go to the Senate. So we went through the Committee on Justice. And after going through the Committee on Justice, there was a vote, and then later on a vote also in plenary. We lost. So the case was not elevated for trial in the Senate impeachment court. Now, every year, there would be an attempt to impeach President Gloria Macapagal Arroyo to quote-unquote immunizer. In other
Naalala ko
words,
nga yun kasi estudyante ako noon, tapos parang lagi nilang may impeachment na naman. Ano
Yes.
ba pagkakaiba nito?
So slowly after the impeachment, we didn't anymore want to endorse any impeachment complaint because alam na namin yung lumalapit sa House na kumukuha ng endorsement ng mga congressmen mukhang bogus na. Hindi seryoso na. So hindi na namin pinapatulan.
But during the time of Chief Justice Corona, he got impeached.
Yes. We did the 1/3.
1/3.
1/3.
Oo.
So
I mean, were there any complications of this kind? Or,
no.
well, I
Wala.
mean, was it clear to everybody
Yes.
what it would take to initiate a complaint?
Yes, because we followed. What was clear in the Constitution is that we had to get 1/3, 1/3, and of the members of the House, and we did that. No, we were able to get a little more than 1/3, and so we transmitted the articles of impeachment to the Senate, no, and then trial began immediately.
Oo, pero nagsasabay ba yun? Yung pag-file ng complaint to the Committee on Justice?
Wala na, hindi na kami dumaan sa Committee on
Oo,
Justice.
because maybe before it was clear that this was the path that Congress was going to take with impeachment. Whereas now, nauna yung tatlo, tapos bigla na lang may fast track.
Yes,
Right?
and even in the explanation of the people who are seeking motion for reconsideration, they even put the timeline. If you'd noticed, the timeline of the vote of the articles of impeachment came before the archiving of the three complaints. So mas nauna pa yung pag-deliberate dito. So what is there to bar in the first place? So again, a factual issue that the Supreme Court can figure that out if an oral argument took place.
Okay, so where does this leave us now? I mean, to your reading.
Well, I would still think that the fact that the impeachment was archived doesn't mean that it's dead. Technically in the term.
It's just in a coma.
It's in a coma. Sabi nga ni Risa, nilagay muna sa library o nilagay muna sa vault. Pwede naman ilabas uli yan pag may desisyon ang Korte Suprema. Now, the question will really be, will the Supreme Court modify their decision, reverse their decision, maybe realize, oops, tayo muna, bakit tayo nagdadagdag ng requirements? Wala naman sa saligang batas. No, I don't know how they're going to do their acrobatics with regard to these questions raised
But to be
by...
honest, if I take a look at the whole situation, it seems to be similar to trying to pass a law on political dynasties, right? What, like if you talk about public accountability, why would you rule
Against yourself.
yourself, right? But what surprised me was the Supreme Court's ruling
Yes.
on it, because I expected, I guess, the Supreme Court to be more prudent when it
Yes.
comes to something that is transcendental. That word has been used many times. It's transcendental in nature because it crosses over branches. From the House to the Senate's role to one Congress to the other. How does that affect the initiation of future complaints?
Well, what observers have said, it makes it difficult. No, now, how do we now go after the high officials of government when their punishment only is removal from office? We want to show the people that even if you are the president, the vice president, if you have committed, the crimes that are identified in the Constitution, then you have no business to remain in office. And the only way to do that is through an open impeachment case filed with safeguards. No, the safeguards, I think, are already placed in the Constitution. If you're talking about due process for the respondent, there will be a trial where the respondent can defend herself or himself, for that matter. And sabi nga ng mga proponents of the impeachment, if in the end, after the evidence that is presented, we lose the vote, we will accept it. We will accept it. But it is important that the evidence to show that the people have lost their trust on the high official should be laid out to the public.
We didn't even get there.
We didn't
yet
even get there.
to the presentation of evidence.
Yes.
But as a Liberal Party president, are you hearing of anything down the lines of filing an actual case before our courts for example, graft and corruption?
Under the Constitution, she's also immune from suit while she is in office, and this is the reason why the penalty of an impeachment is removal from office only.
Yun muna.
Yes.
Oh, okay.
Because of the immunity of the vice president and the president.
Well, I guess the ball is back in the Supreme Court's court.
Yep, that's true.
Right? We await if they will, somehow change their minds
Yes, we will
due
wait.
to the new facts or presentation of the correct facts involved here. Maraming salamat po sa inyo for joining us today and weighing in. We have Liberal Party President Erin Tanyada. Don't go away. More matters discussed after a quick break. Keep it here on One News. Welcome back. You're still watching Morning Matters here on One News. Former Supreme Court Associate Justice Adolfo Ascuna says the Senate's decision to archive the impeachment complaint against Vice President Sara Duterte was a sound move as it allows for future reconsideration. Let's discuss that statement with Justice Ascuna himself, who joins us on Morning Matters today. Magandang umaga po sa inyo.
Magandang umaga po sa inyo din, Gretchen.
Good morning to the author of Forthwith. Okay, Justice, can you explain why you think archiving is a better option than tabling?
Karen, Gretchen, I think the archiving is a good move on the part of the Senate because it does not preclude the Supreme Court from continuing to consider the pending motion for reconsideration filed in the impeachment case by the House of Representatives. Ito po ay lamang tinabi lang muna just in case the Supreme Court modifies or changes its decision, it can be revived. It is not dismissed. It's not dead. And
Correct.
so it preserves the status quo.
But isn't that the same as tabling in concept? Tinabi lang din muna.
It's not the same as dismissing because the
But
case can
tabling po,
be
tabling.
removed.
Oo.
It's without prejudice to being retrieved from the archives and considered again if necessary.
But how about tabling? What would be the difference between archiving and tabling?
In tabling the matter, Gretchen, it becomes possible to dismiss it still the same the next day. A matter that is tabled is again put on the agenda the following day. So hindi pa tapos. It can be dismissed. Whereas once it is archived, it can no longer be dismissed.
So you don't agree with Senator Tito Soto's statement that he knows for a fact that when it is archived, it is dead.
It is not dead, it's just sleeping to my mind because it can be recovered.
Has the Supreme Court used this word, archive? Is there a proper definition for that, official definition? Or is it arbitrary?
No, not that I know of, but it is a practice on the part of the courts also. In criminal cases, sometimes the judge, for one reason or another, finds that it cannot proceed with the case. It archives it. And in archiving criminal cases, it is subject to being revived on motion of the prosecution within 1 year. If it is not revived within 1 year, then it is dismissed. That's in the courts. So there is an institution of archiving in the courts. And the legislative chambers have their own archiving methods and their own archives and their own rules regarding their archives.
Okay, Justice, what if the Supreme Court, in its decision, operated on the wrong facts? What happens? Does it nullify the whole decision? And has that ever been? Has that mistake been made before by the Supreme Court, where from the basis itself, from the facts that served as grounding for the actual decision, that the Supreme Court got it wrong? And do you think that they could have acted in haste in this situation?
Yes, Gretchen, there have been instances in the past where the Supreme Court revisited its decision and even modified it. And this has been cited by other observers. I remember the Keppel case, the mining case. There have been many cases. The fact is the court, as long as it's not yet final in the sense that the time for motions for reconsideration have passed, it can still be changed by the Supreme Court. So that is the situation now. It is pending motion for reconsideration. and the Supreme Court has the power to change its decision. And even if it's final, executory judgment has been entered, the Supreme Court, in some cases, even modified its decision. Final, already made judgment, the entry of judgment in the Keppel case. Why? Because there is a rule in the rules of court that the court has every power, retains the power to change its decision, even final, in the interests of justice, to prevent a grave miscarriage of justice. Nasa rules of court po yan, anytime, even a final decision. So the court retains the power to change its decision now because it's still subject to motion for reconsideration. And secondly, even if it was final, the court can always revisit any decision in order to prevent a grave miscarriage of justice.
And how often has the Supreme Court overturned its ruling when it voted unanimously on a certain decision? Because that was also a point of argument in the hearings. Sabi nga po ni Senator Marcoleta, saan nyo ba narinig na nag-vote na sila unanimously, na binaliktad pa, and it's most likely not going to happen? Do you recall any case that had a unanimous vote and then they overturned it 180 degrees?
Okay, Gretchen, the former Senate President Tito Soto cited two cases, Bigal Bulaan mining case and another case. I remember one case, the Keppel case, where even after entry of judgment, Supreme Court modified its decision. The point is that the decision of the Supreme Court now is pending a motion for reconsideration. And they don't have to change their votes, but they can modify its effect. There are two ways in which the Supreme Court can still modify the impact of its transcendental decision without changing their votes. One is by applying the doctrine of prospective overruling. That is by saying that our decision today will apply only to future cases, whereas the present case has already been operated under our previous rule, should continue. That's one. Maintaining the same votes. The other is maintaining the same votes. They say that this situation is very unusual. It involves very rare occasions of factual conditions, such that it is not suitable to frame a general law based on these unusual facts. Therefore, we consider this decision as good for this case only. That's what we call pro hac vice. There have been, again, instances where the Supreme Court said that its decision in that case is pro hac vice, in which case it's not binding on future cases. So those are two instances. They don't have to change their votes, but they can change the impact of their votes.
Okay. So I want to go to the second one, which is the ruling for this case only. Could the Supreme Court change the rules for this case only? And say, for example, yun nga po, in this case, it should have given the charges to the accused and also ask for a presentation of evidence to this case only. Isn't that also unfair? Because it based the filing of the impeachment complaint on a previous ruling. I believe that was the Francisco versus HOR case.
Yes, Gretchen. The portion of the decision which requires notice and hearing even on the second mode, that is where Congress itself is the complainant, and it does not in the Constitution require notice and hearing. I believe that that portion of the decision now is obiter dicta. That is, it's not a binding portion because it's not necessary to decide the case. The ruling, the ratio of the case now is that the present articles is barred by the 1 year period, and therefore it has no legal existence, and therefore the pronouncement elsewhere in this decision that the articles should have been subjected to notice and hearing first before being sent to the Senate is obiter because it says it does not legally exist. So any further pronouncements on what it should have been subjected to is what we call in law obiter dicta, not binding. So they can say that this is recommendatory only for this case and future cases not binding, but maybe persuasive. That's what will happen if they say pro hac vice.
Okay. Hearing you now, I mean, and hearing your thoughts on how the Supreme Court could correct itself for the future impacts of transcendental ruling, is it safe to say that you don't agree with how the Supreme Court decided?
I respectfully do not agree with all of it. I said maybe they can frame a new definition of initiating proceedings, different from the prevailing definition of Francisco. So that is within their powers. However, to apply it retroactively, I said is unfair. And therefore it should just be applied prospectively because the previous rule or definition came from the court itself. It did not come elsewhere. So the House just followed a definition which was promulgated by the court itself. So unfair to impose a new definition on it now. That is view only, Gretchen. So it's up to the court really to finally decide what is its final ruling on the matter.
Well, a group of lawyers, academics, and citizens led by Justice Antonio Carpio and Conchita Carpio Morales have turned to the Supreme Court to request for a status quo petition, anti-petition. And they wanted oral arguments or an oral hearing of how the process was conducted over at the House before the Supreme Court even decided. But it reiterated that its decision was immediately executory. Do you think there was something strange there? And could an oral hearing be done? Or is it not the usual process, given the complicated nature and I guess the needed clarification of facts?
Yes, the matter of requiring the parties to submit to an oral argument is within the discretion of the court. But since this is a matter of transcendental importance, many quarters, including some former Chief Justice, recommended that there should be an oral argument. And I submit that it's not too late to hold one because the court has the power to order an oral argument on the motion for reconsideration, in which case the House will have a chance to ventilate its side of factual issues, among others, such as what really happened, whether there was a plenary vote or not on the amendment, on the articles that is now the subject of this case. That is the importance of oral arguments, and it is still possible to hold one, and I believe the court is setting the proceedings towards that because it required the other party to comment on the motion for reconsideration. And usually after issues are joined by the motion and the comment to the motion, the court will usually require the parties to submit to either memoranda or oral arguments.
Well, one thing is for sure, Justice, is that there needs to be a clearer set of rules when it comes to impeaching public officials. especially in unusual circumstances, for this not to happen again. But others would argue that the bar has been raised even higher in terms of what is required to actually impeach a public official. Do you agree with that, na mas mahirap na po ngayon mag-impeach and the Supreme Court's ruling actually gave room for more bogus complaints to be filed? And how would you, if given the chance, recraft the law? That you said na if the Supreme Court were to decide, they should set definite rules on this and apply it prospectively.
The matter of requiring further steps to be taken before the second mode, that is direct filing by the House of Representatives, may be adopted, should be fully ventilated in the oral arguments, so that it will be clear whether or not the court wants it to apply to future cases, or wants the matter to be resolved in a future case where it is necessary to make a ruling. So is it overturned or not? That should be clarified in the oral arguments. To my mind, adding these requirements at this stage of the impeachment would make impeachment unduly difficult and defeat the main purpose of the article, which is accountability of high officials.
Yun nga po, no? Because in the ruling of the SC, they required presentation of evidence, and even that one is difficult to do because kung titingnan nyo nga po, as I said earlier, in the ICC itself, ibang proseso pa po yung presentation of evidence, and there is protection that is needed for the witnesses themselves. So to lay it down on the table of the accused would be a difficult step, right? How do we make this better? To your opinion, when you wrote Article 11, how easy should it be to file an impeachment complaint? And taking a look at what happened over at the House, they had 3 versions of impeachment complaints and one that applied to the 1/3 vote. What room should be given for the House to reconcile different versions to make sure the impeachment complaint is credible?
Yes, Gretchen, I think that that portion of the decision should be revisited, because that will really make impeachment unduly difficult, and besides, to my view, that would be contrary to the Constitution, because the Constitution does not require a hearing on the part of the plenary vote under the second mode, and requiring a hearing under a 7-point procedure would not be constitutional, because that would be intruding on the exclusive power of the House to adopt rules to carry out the provisions on impeachment of the officials and render accountability from them. So, palagay ko dapat tingnan ulit ng ating Supreme Court yung portion na yan.
And finally, where do we go from here? I mean, is the MR just the way to go, to your view, and how does this impact future decisions?
Yes, the very important ruling of the Supreme Court is transcendentally of transcendental impact on not only on the future decisions but on the principle of accountability, which is what this Article 11 is all about. And you know, Gretchen, the rule is you cannot file a criminal case against these high officials without first resorting to impeachment. And therefore, if impeachment is made unduly difficult, there will be no more chance to file even criminal cases, because impeachment is a requirement before you can file criminal cases. So the whole framework of accountability will collapse.
It is the same thing that Congressman Tanyada mentioned, that we must go through the process of impeachment because they are immune from suit while they are in
Correct.
office. And there is no other way to obtain justice than that. So we should protect and safeguard Article 11 of the Constitution. Okay, maraming salamat po sa inyo sa paglilinaw. Marami po kaming natuklasan dito ngayon sa aming programa. We have former Supreme Court Associate Justice Adolfo Ascuna, again, the author of Forthwith, joining us this morning.
Thank you.
In other news, President Bongbong Marcos said he will convene a conference with key stakeholders to craft a clear government policy on online gambling. In his latest podcast, the president stressed that online gambling should not be compared directly to Philippine offshore gaming operators or POGOs, which have been linked to criminal activities. He explained that online gambling poses a different set of concerns, particularly addiction, mounting debt, and the exposure of minors to gambling. Marcos said the social impacts require careful study to protect vulnerable sectors of society.
With online gambling in general, what is the problem we're trying to solve? What we're trying to solve is that hindi malubog sa utang ang hindi naman wala namang kaya, pero napapasubo dahil sa sugal. Mga bata na natututo magsugal. Let's focus on that. Paano natin patitigilin yan? These are the things that we're going to examine, and we will come up with a plan to make sure that we address the problem.
The Bangko Sentral ng Pilipinas is finalizing new rules requiring e-wallets to impose stricter controls on online gambling payments. The measures include biometric checks, daily transfer limits, time-based restrictions, and tools for users to set personal spending caps. Now, these aim to curb addiction, fraud, and financial harm. Globe CFO Carlo Puno said GCash will roll out new features such as self-exclusion options and customizable top-up limits. He added that users can even choose to block gaming activities temporarily or permanently. Tofrada, head of corporate affairs of Maya, said they are also committed to introducing the added controls and friction. And that wraps up today's episode of Morning Matters. We hope we've given you the right start to your morning and your weekend. Let's go ahead and make the day matter. My name is Gretchen Ho. We are One News, all sides, all the time.